Hi, this is Melina Stratos and Austin Wolf, and we are doing a presentation on bankruptcy. There's a PowerPoint presentation to go along with this, which is about 13 slides long, and we're submitting this for your approval.
All right. I guess first we're going to start with an overview of bankruptcy, what it is, what it accomplishes, and how it's done. First off, the goals for bankruptcy is that it's a fresh start for debtors. It's broken up into two basic courses, or courses of action. One being a reorganization of your assets, the other being a liquidation of your assets. And ideally it achieves the equitable distribution of a debtor's property for all the creditors.
So bankruptcy is governed by federal law, which is 11 U.S.C. Section 101, which is the Bankruptcy Code, and it sets forth the federal procedure for insolvent debtors. And there are many forms of bankruptcy, but this presentation is going to go over four, which are divided by chapters. So first of all, there's Chapter 7, which is also known as liquidation, and this is involuntary because it's basically a lawsuit. And you have you must have at least three types of unsecured creditors totaling with claims over $5,000. And in this type of bankruptcy, after the debtor discloses all the property that he or she owns, the debtor surrenders this bankruptcy estate to a bankruptcy trustee who's appointed by the court. The trustee then will divide the bankruptcy into what the debtor can keep and what the debtor cannot keep. And the property that the debtor cannot keep is going to be liquidated. Following the liquidation, the trustee will distribute these funds to creditors on a pro rata basis. And time has proven that it's likely that the creditors will only receive a fraction of the amount owed to them. And just as an aside, debtors have the right to transform their involuntary Chapter 7 bankruptcies into voluntary Chapter 11 bankruptcies, which we're going to discuss in just a second. So the next three types of bankruptcies, 11, 12, and 13, are all voluntary, meaning that the debtor can elect to go into a bankruptcy proceeding. So first, we have Chapter 11, which is a corporation has to prove to the court that the rehabilitation is possible, and they're going to provide a blueprint or a plan, a feasible payment schedule. The court's going to find either that this rehabilitation is reasonable or unreasonable, and then they're going to hold the debtor to that plan. Chapter 12 is for family farms and commercial fishing, which sounds like it fits this course perfectly, but it's for the farm owners, not the workers. And it's for family-held corporations, but as a farmer, you're not confined to this chapter, you can use many. And it was enacted in 1986 after a huge economic turndown for farmers. So within this chapter, it's very similar to Chapter 13, but it also includes provisions of Chapter 11, which we're going to go out in detail soon. And then finally, Chapter 13 is for consumer debt adjustments. Again, this is voluntary, so a debtor will approach the court and file, and the court will grant it if they find that rehabilitation is possible with a payment plan. So again, this requires a payment plan just like Chapter 11 and Chapter 12, and it's for individuals with a regular source of income. You cannot be put here involuntarily. That's really important. And the last thing I want to point out is that if you go into bankruptcy, it stays in your credit report for 10 years. So, let's see. Next.
Okay, I guess we'll just go over some basic vocabulary of the bankruptcy system. The debts are broken down into secured and unsecured debts, and so a secured creditor or a secured debt is any type of debt or loan that has a form of collateral that's backing it up, like a home mortgage or a car loan, because the home or the car is the security that's backing it up. And an unsecured debt is any loan or debt that doesn't have collateral, like a credit card. A priority claim, the Bankruptcy Code recognizes that the right of some claims are paid before others, and so they give a list of 8 types of claims, which include administrative expenses of the bankruptcy estate, such as the attorneys, that's the second priority. the wages of the employees up to $10,500, which is the fourth priority, and the claims of persons engaged in the production or raising of grain against a debtor who owns or operates a grain storage facility, which is the sixth priority. And collateral is any real or personal property that guarantees a loan, like a land or a house, like I just explained.
Let's see. Okay. Got the long ones. All right. So again, to go into detail, for Chapter 7, a debtor can go into Chapter 7 bankruptcy voluntarily or involuntarily. So in this type of bankruptcy, the bankruptcy court assumes the responsibility to repay for most of the unsecured debts. So this means that the debtor is allowed to keep exempt assets which will be set forth by the court. And again, in this case, the court-appointed trustee will possess all the non-exempt property and then liquidate them in order to pay off as many of the debts as possible. What's important to note is that the court conducts a means test to determine whether the filing of bankruptcy, either by the creditor or the debtor him or herself, is abusive. So what they're going to do is compare the debtor's income to the state's median income, which is available online. And then they're also going to compare the debtor's financial ability to repay the debt. If in any way none of these comply with what the court is looking for, they may find that bankruptcy is unavailable for the debtor or the creditors. And also for Chapter 7, prior to discharge, the debtor must attend a pre-bankruptcy counseling and pre-discharge debtor education, and failure to do so may result in the bankruptcy court not allowing discharge of the debts.
All right. So Chapter 11 is the first of the reorganization, rehabilitation chapters, as opposed to liquidation. And this can be involuntary or voluntary, and it allows companies to continue functioning while they're undergoing a reorganization of their debt repayment plan. And I think individuals can file for Chapter 11 as well.
Yeah, it's harder.
Mm-hmm. But so there's no means test for this one. And the debtor is obligated to come up with a repayment plan and have it approved by the court. And the plan becomes the debtor's blueprint to repay their creditors. And the creditors have to be divided up into 3 types of classes. And they give the creditors the chance to vote on the plan. And there's a different procedure that they would follow should the creditors object to the plan. Mm-hmm. And it can be a reorganization of business or liquidation of assets under Chapter 7, although the Chapter 7 is kind of like a privileged, it's like immediate relief, so they don't like to grant it unless that's the most necessary thing. Mm-hmm. And so it gives the trustees a right to operate the business, like I said, and it gives the debtor a chance to get favorable loans on new terms. And they can now reject or cancel their contracts, and they are protected from litigation by an automatic stay. Any litigation that was pending at the time of filing, it gets stayed until, I believe, until discharge.
That sounds right. So
and there's a time after filing that the debtors have the exclusive right to propose the plan. The repayment plan, before the creditors can jump in and say and put in their 2 cents as to how they want the plan to proceed. And so that's Chapter 11.
Okay. So next, if this slide's going to work. Oh, you can do this.
Oh yeah. Okay. Here's an example of, if you could see the slide, you would know what we're talking about. But it's WorldCom's repayment plan after it declared bankruptcy in 2003.
Here, I can zoom in.
And
so it divides them like...
Yeah, it divides them up between their secured and unsecured claims. And I don't really know how to explain this without having you look at it, but...
And then it says whether they're entitled to vote on repayment plan or not, and the type of class of creditor they are, as set forth statutorily or by secured or unsecured.
Right.
Which basically just gives full disclosure to all the creditors, like these are everybody that's owed, and this is the order you guys are going to get paid in. So if you're at the bottom of the list, whoops. And then this is the
there's a WorldCom distribution example. He spelled WorldCom.
oh, good job, good call, good catch. Okay, so now there's Chapter 12 bankruptcy. So first of all, it's specifically for family-owned farms or fishermen with regular annual income. And the federal statute gives forth a really complex definition of family farm, but we're not going to go into that right now because we'll be here for a while. But this type of bankruptcy must be voluntary. It cannot be involuntarily brought on by creditors enforcing, trying to get their money out of farmers or fishermen. And basically, the goal here is to confine the filers, these fishermen or farmers, to people who actually have a farming debt, because they're going to create, this has a debt limit of $3.54 million, and it's required that half of the debt arise from the farm or the business, the fishing business itself, and not from unsecured sources such as personal credit. So here, this was again made in response to the tightening of agricultural credit in the mid-1980s. It was made specifically to help farm workers. It wasn't made to work against them. And we found that there are over 300 filings of Chapter 12 bankruptcies each year. And it's very similar to Chapter 11, except that it's narrow to the profession. Okay, so that's next. Let me just zoom out for you. Oops. Okay.
Okay, next we have Chapter 13, which is called the wage earner bankruptcy. It has to be voluntary, and it's for people who earn a regular income. It's for individuals who earn a regular income. And as of April 2010, the debt must be below $360,475 for unsecured debt, and for secured debt, it has to be below $1,081,400. And it's basically the same as the other rehabilitation chapters, except for it's just for individuals who have regular income, and they come up with a detailed repayment plan, and normally the individual gets to keep his or her personal property, and the creditors usually receive less money because of the absence of liquidation. In the plan, it's usually a 3 to 5 year repayment plan, and it has to begin 30 to 45 days after the case has started. Let's see, and it can stop a foreclosure on a house, and you can get a super discharge of debts, which I'm not really entirely sure what that means, but
I'm really proud of it.
Yeah. But they have to provide that unsecured creditors will receive at least as much under Chapter 13 as they would have under Chapter 7 if the debts were liquidated.
All right, so for one of our last things is we're going to quickly compare Chapters 7 and 13 bankruptcy, just to reiterate. So Chapter 7 is one that can be done involuntarily or voluntarily, and it's for personal bankruptcy. It's quicker and provides a fresh start to the creditors. You can only file Chapter 7 once every 8 years, and this liquidates your property. There's no choice in the matter. Chapter 13, on the other hand, you cannot file if you received a bankruptcy discharge within the last 2 to 4 years, and it's a better choice for people who want to keep some of their non-exempt property. So if you're afraid of some of your personal assets being liquidated, you want to lean towards Chapter 13 rather than Chapter 7. Okay, and then last slide.
Okay, discharge is, as you might have guessed, the end of the line for the bankruptcy procedure, and it's the point where the debtor is released from all personal liability. And what happens is you get a permanent order from the bankruptcy court preventing creditors from taking any more action on discharged debt. And that includes telephone calls, letters, things like that from creditors. And the timing varies by chapter, but with Chapter 7, the discharge happens promptly as long as no one files a contrary motion to the court. And with Chapters 11, 12, and 13, the court will grant as soon as possible after the debtor completes all the payments as set forth under their plan, and it usually happens between 3 and 5 years after filing of bankruptcy. And the courts can deny a discharge if the debtor doesn't complete credit counseling, or I think there was a couple other conditions attached, like if they don't follow their repayment plan the way it was set up in the blueprint, or things like that. But once discharge is the end of the line, and
the creditors can't go after you anymore. They can't even communicate with you. All right, well, that's it. We went a little bit over, but I'm sure we'll take care of that. Thank you.
See ya.